We have with us today people from all over the globe. Only 6 of the students are AU students, and even one of them is living in Europe now. And the way we've been running it is to turn it over to a student team. And one of our Arcadia fellows at AU, Lokesh, is leading the team for today. Lokesh, over to you.
My question is that when we are applying the fair use test, are we not again discounting the idea of using a different language? Because at one part you've talked about that the use of that that humans experience these works in a different way. For humans, it will be a work, but for machines, it will be a data. So the idea is about the access. So by applying the fair use principles, are we not again bring the entire debate to the idea of use? Because if it is a data, then it won't be used in the context of copyright law. And given this question, the countries which do not accept the the idea of four-factor test. For example, India does not apply four-factor test in every cases. In like countries like them, like fair use test will not actually work. So in those countries, how would you argue that the access of the data is completely fine from the purpose of copyright law?
Those are such good questions that I'm going to actually take them in reverse. This is a very US centric paper because most countries don't have fair use. Some countries do have fair dealing, which shares some DNA with fair use, but doesn't always have the same flexibility. And as you learned from your previous speaker who laid out for you what the text and data mining exceptions look like globally, you know that India is not the only country that doesn't have something like fair use. And that is a much bigger, broader problem that can't be solved with the creative application of existing law. That requires new laws in new places to do new things. And while I am very excited about all of those potentials, this paper is only limited to what we can do here in the US with what we have. That still creates inequities because it means that US researchers have advantages that are not spread out equally across the globe. And that is a huge problem with the importance of fair use taking central conversation time without addressing how this would operate in other countries. So you're totally right about that. The other question is sort of this data versus works. And the way that I would frame this, and Matthew Sag is really the king of this, so I would encourage you to ask a similar question of him. The way that I think of it is when you start using it, it is a work. It's a copyrighted work. It's consistent with the language of the Copyright Act. But through the transformation it undergoes to become machine readable and be usable by AI, the transformation is actually into training data. We use a different word to reflect that transformation, which is a core principle under that first factor of fair use here in the United States, to reflect that something has happened to this data. Technically, the work is the same when when it's being an input, but something happens to it mechanically and through the exercise of human autonomy to change it into a work that is closer to fact. That's what Judge Traxler was saying in the X. Re Vanderhyde case. And that's also what we see in some of the additional scholarship around robotic readership is you are taking a work that is creative expression and transforming it into something that's closer to a fact, which have not been protected by copyright law in the United States and in most countries.
I have one question from a team member, Lucia. In the article, you conclude that the fair use doctrine can be applied in this field as well. How could that make high risk databases become low risk ones for AI creators? Do you think a landmark case is needed? What other kind of solutions could there be, especially for small AI creators such as labs and universities to be able to compete with much larger databases without risk? Secondly, about the size of the data access that AI creators have, it was not entirely clear to me what role of copyright plays in that situation.
I'll start with the first question. How can we help smaller labs and researchers compete with the likes of Facebook, IBM, Google? Well, ironically, researchers are in the best position to use high friction works because their uses are privileged under fair use. In the preamble to the 4 factors that everyone kind of knows about and thinks about, research is one of the public benefits that is privileged for this kind of use. So a lot of researchers who are competing are actually in a really good position to rely on fair use. They just don't know it because the messaging around using copyrighted works, including from their own institutions and perhaps even from their own copyright librarians, may be really conservative. So the bigger question is not whether fair use is up to the task. I think the question there is whether the norms around using copyrighted works have been adequately set to be realistic for researchers who are doing this from a public service place. So I hope that answers your first question. So the role copyright plays is actually very closely related to things like resource power and market power. If you have a lot of resources and market power, you can build a system that acquires copyrighted works as a byproduct of your main product, right? The goal of Facebook is not to be a AI training data acquisition tool. It's to, I mean, I'm about to say this euphemistically, but it's to connect people. It just happens that connecting people produces a lot of data that can be used to train AI systems. But you're not going to have billions of users if you start a social networking company tomorrow, which is where the resource power and market comes in for the build it models. On the buy it models, it's even more stark. Nobody who comes on the market right now is going to have market share and resource power like IBM. They're also not going to have some of the baggage from World War II, but they also are not going to have millions of dollars to partner with Memorial Sloan Kettering to do cutting edge cancer research. So that's really where the copyright comes into contact with the resource power and market power, is because you have resource and market power, you don't worry about the copyright issues because you've either built a model to acquire it legally through licensing, or you can buy it with capital. Does that make sense? You're not, to say it really bluntly, you're not fucking with fair use. You're doing it the right way. My next paper is about feminist cyber law practice. So stay tuned for that one, which unfortunately has nothing to do with global relations and everything to do with how oppressed people are. Well, I guess it does, how oppressed people are oppressed similarly almost everywhere. I think what's really important about this conversation around looking about what this does globally is to recognize that while fair use can be a powerful source of countering oppression in the United States, it has the converse and perverse reverberation of reinforcing colonialist ideas by reifying works by Americans and research by Americans and corporations that are American. And unfortunately, there isn't really a way to separate those two things out. You can't get the benefits without getting that colonial impact. And there is not a way around that. I mean, obviously, copyright law itself is rooted in, providing rights to the crown and making sure that largely privileged white men could make money off the works of other largely privileged white men. That is the foundations of copyright law dating back to the Statute of Anne in 1710. However, I do think we've come a long way since then. The 1976 Act, while it was a white woman, was largely written by a woman here in the United States. And while it had some drawbacks, such as getting rid of formalities, which made fewer works join the public domain, and extending copyright terms, which likewise had the same impact, she also was the person who helped codify fair use. The reason this isn't just a judicially mandated test from Folsom versus Marsh dating back to the 1800s is because a woman pushed for it, because she believed that in order to have a truly balanced copyright system, people needed to be able to use works without consent. And I think that that's something really powerful to bring to the conversation and keep in mind, even though it doesn't undo the colonial impacts of copyright law generally. And I don't know if anything can.
Although a very few countries around the world have fair use, almost every country has at least one research exception. And most of those research exceptions are not as open to fair use, but you don't have to go all the way to fair use to take care of, at least the research side of the coin where most of this debate is taking place. So Lokesh, even in India, there is a research exception in India. So one question is, can it move over towards fair use? But another question is how you interpret what you have, right? And so those can be wedges of analysis that you can bring to bear. But I love that phrase that oppressed people are oppressed similarly everywhere, and bringing that to the relation between the North and the South. And the bias problem that Amanda is pointing out is a global problem as well.
I want to just honor the fact that bias looks different everywhere. There's an amazing paper that I cite in this paper that talks about how facial recognition developed in East Asia is significantly more accurate for East Asian faces and less accurate for Caucasian faces, whereas face recognition developed in the United States is most accurate for Caucasian people, but least accurate for groups across the spectrum that are non-white. So the biases exist everywhere. They just don't always take on the same tone or tenor. However, as you might expect, the same groups of oppressed people are often the least likely to have accurate AI that represents and reflects their interests across both the global north and the global south.
First, Amanda, thank you for your lecture. I love your work. I follow your work very closely, and I'm already looking forward to this new article on feminism and internet. So I hope it comes out soon. My question relates to what we were talking about right now, and to Lopesh's first question as well. And when we're thinking about tackling bias and doing that by fair use, and knowing that fair use will grant us access to data in the US and maybe in fair dealing countries. My question is, in what dimension does it solve the problem? Does it solve the problem only for the US bias, or as you said, that a facial recognition system developed in India or in East Asia is better for recognizing faces from East Asians and so on? But wouldn't it be even better if we could find a tool or an incentive for us to have this database that is big enough to work with every face, especially when we're thinking in a world that is becoming more and more globalized?
It's a really tricky question, and I'm going to drop a link in the chat to my new article that answers a little bit of it. But I think for certain technologies, and face surveillance is one of those technologies, fairness is not the goal. Its elimination from public discourse is the goal. Face surveillance is too invasive, too privacy harming, and too damaging to, quite frankly, be allowed to be used by law enforcement, in my opinion. So every time we hear a story of, say, a trans Uber driver who can't get into their car because the face recognition system doesn't work well for trans faces, the reality is, yes, that could be fixed with harvesting a bunch of faces from marginalized people. But that in and of itself is a type of oppression, which Anna Lauren Hoffman has said, inclusion can be oppression, speaking about face surveillance. And I think her point is really well taken, because when we're talking about whether or not you can get into your phone, it's very urgent that everyone be able to use accurate face recognition equally. But when it comes to whether or not the government can surveil you using your face, we may not want accuracy. We may have other normative goals that we are trying to set forth and advocate for. And potentially one of those is abolishing face surveillance entirely. So if you're curious about that argument and that framework of that sometimes inclusion in the data set is its own version of oppression, and accuracy may not be what we're truly striving for as a normative value, check out Resisting Face Surveillance, my other piece about this issue, because I think face surveillance is really the example of technology that kind of breaks that everything should be fair use. There has to be a limit somewhere, and as I posit in that paper, the limit is invasive facial surveillance for all people by law enforcement.
I feel like that's a very interesting and powerful academic move, in the sense that Amanda has written a very strong argument that fair use is an answer to one problem, but then has kind of switched sides. And as she said, there has to be a line somewhere, and has tried to define that line. And I think it's not always common for academics to try to find both of those lines. And so I think that's it's very rigorous work.
Another topic that I saw in your paper, and I'd like to hear more from you about it, would be on the topic of accountability and verification of what has been used, because part of these topics, part of these questions could possibly be addressed with proper accountability processes and more verification. And as well as in academic research, we also have that problem. How can we verify the data How can we verify that the results were fed with the correct data if we have no means to access the data in order to look at it and see if everything's all right? So I'd like to hear more from you on this side of the topic, and more specifically, how that could translate to accountability processes in algorithmic bias in real life issues. We were talking about surveillance, but we can talk about recognition in applications such as Google, for example.
Yeah, the accountability question, in my opinion, is deeply tied up with the fair use question. The reason these companies don't make their data sets publicly available by and large is either they're using a build it model, so they consider that data proprietary and there's no copyright issues, and you were at some point a user of the technology, so they feel no obligation to be transparent about what they're doing, right? That's one piece. That's the Facebook model. They're not going to publish the profile pictures of every person on Facebook to show it was a training data point. And nor should they, because then it could be reused by perhaps more nefarious, I don't want to say nefarious to imply that Facebook is not nefarious, more nefarious actors who are using it for other purposes. So their transparency could actually be a harm, and it's not really part of the business model. For the buy it model, IBM purchased a ton of cancer patients' data and doctors' data, frankly, from Memorial Sloan Kettering, or they purchased access to it. They're not going to share that data because it's also considered proprietary, and they have really no need to. Some of that information may be copyrightable, like the doctor's notes, but it may have thin copyright. And at the end of the day, nobody's probably going to come along and create a model that competes meaningfully with IBM's cancer detection software, even though it would be amazing to have something that was more accurate and minimize some of the biases that we've observed in cancer detection software. The big question is, a lot of these companies are secretly relying on fair use. And I've given this talk where there are people in industry before, and they look so nervous. And I always joke with them, some summer associate 10 years ago probably wrote a memo about whether or not using copyrighted works as training data was fair use, and you kind of ran with it. And that's a little glib because I'm sure some of them did more sophisticated research with actual people like scholars and people who are higher up in their staff. But really, this was kind of kicked to people a long time ago when a decision was made. And as long as there's no solid case law on whether or not this is fair use, these companies are going to continue relying on that loophole to withhold their data from scrutiny and accountability. So until the fair use question gets resolved, we actually can't truly have algorithmic accountability, in my opinion. Because as long as there's an open question about whether they're committing massive amounts of copyright infringement, they're never going to give that data up. Now, the next question is, say we get a Supreme Court opinion saying, most uses of training data, copyrighted works for training data are fair use. Maybe they read my paper and they have a carve out for facial surveillance. That's what we can all hope for. But say they say most of it's fair use. Then there has to be a bigger question about what we're willing to tolerate from these companies and what kind of movement we're going to have as a normative issue. I don't think the right move here is necessarily legislating transparency through the courts. They've tried to do that with content moderation in California, and we'll have to see how it goes. They may find out that they don't get the data they want. They don't get very much data. They don't get very good data. It's really a good test case to see what legislating accountability looks like for big tech. And right now, we've seen that the law has been passed or signed, I think yesterday, but we don't know what the actual results are going to look like. I think the big thing is we need to continue putting pressure on companies to show that we are unsatisfied with the current level of transparency, because without transparency, we can't have accountability. And without fair use, we can't get to that transparency. Does that make sense?
Yeah. I think it casts a different light on the subject. I haven't thought about it. And related to that, do you think it would make things easier if we had something into the likes of a more specific exception in law rather than just fair use, because we would have something more solid coming from legislators that could possibly help discussions a little bit, give something of an anchor for discussion. What do you think about it?
I love your optimism. I don't think anything good is going to come out of Congress related to copyright law unless it's codifying controlled digital lending as an acceptable practice by libraries. I'm trying to think if there's another exception, but I'm struggling to think of one, because fair use is so impressive, because while it doesn't always provide certainty to the people who rely on it, it is flexible, right? If fair use had been codified in the 70s to involve even, say, particular technologies, it would be like about the photocopier and the fax machine. Like, you're not getting email, you're not getting instant messages, you're not getting cloud storage, you're not getting any of those things if there's more specificity in the law. And while I think Congress is capable of doing very many impressive things, there are a lot of doofuses who don't understand the basics of technology, both in courts and in Congress and at corporations. And having those people make the policy that defines how we can exercise our free expression and create a fairer society, as you might imagine, makes me deeply nervous.
We'll be looking at some of the other kind of specific text and data mining exceptions around the world. And maybe after Melissa asks a question, I'll show you Japan's, which I think really echoes some of the cases that Amanda mentioned. So Melissa, you have a question, please join us, welcome.
I've been involved with digitizing collections in different institutions since like the mid-90s. And I've watched how in some ways we're dealing with new questions and we're not really dealing with new questions. And one of the questions I've sort of had for myself in recent years is the way in which, as we've looked at, what is easy to digitize from a copyright perspective for a museum, a library, an archive. And you say, oh, it is in the public domain. We love the public domain. Let's digitize those. But what we're really doing, especially if that is being used as data for AI, and it is in some cases, it's replicating the narrative of what's physically contained in our buildings from, say, the 1920s and earlier. And there are more things than I can imagine to learn from this material, but without controlling for that or thinking about those things, it's a real problem.
We've had a range of best practices that have been sort of a synthesis of practice in the field. And they were meant to empower people's application of fair use in these kinds of settings. I'm a little concerned this number of years out, and I'm going to stop, is that they may be being used by people who are fearful as a ceiling, not a floor. And I'm not sure how this plays into the use of data for AI, but I think that there's a connection in terms of the data that is made available by universities in worrying about these things. I'm going to stop. I'm sorry.
No, these are such good questions. I'm going to take them backwards and start with the sort of phenomenon of what starts off as a best practice that's meant to empower fair uses ends up being seen as a more conservative document that constrains fair uses. And I think what you need there is guidance from the top, that fair use is not supposed to be scary. You need especially at an institution like a law school, right? Lawyers are not known for our like dilly-dalliances with risk. That's not really the reputation we have. We're traditionally very risk adverse. But if you have a GC and a copyright director, or whoever the director of copyright is, and a director of the library who believes in that, you can get really interesting stuff. The model I look to, and I'm very spoiled here at Georgetown, is we look at what Michelle Wu did with our library's controlled digital lending collection. When you have librarians who are not afraid of embracing fair use and are interested in using copyright creatively for social justice, you can go hard and you can go far. But it is a collaborative effort that requires getting sign off by a lot of people. And one thing that we can do as scholars at our individual institutions, to give you something concrete, is be that voice of saying, well, what if we were the first, but what if the first was the best? What if we did something really amazing and novel and cutting edge and impactful that promotes social justice? And yes, it can be scary, but we can always be the person in the room to say, yes, but we should. Yes, but we must. And so that's what I try to be in my experiences, but I've seen other people do it really successfully. And I think that can be very powerful. It's not going to work everywhere and it's not going to work every time, but it can go further. Talking about the global access issues, there's so much to talk about in just the US alone that I think it's really hard to give every country that deserves attention the attention it deserves. And I have taken a very American approach in my scholarship for that reason, because there are scholars who are really adept at the art of international law or the art of comparative law. That's not what I'm trained in, and that's not what I specialize in. And that's not to say that I don't want to talk about what happens internationally, because I think it's urgent and important. But my approach is already, by the time I've hit 50 pages and I haven't even gotten to other countries yet, I've got to start calling it quits because nobody wants to read more than that. So in future scholarship, I am hoping to do more. And actually in the book I'm co-editing about feminist cyber law, we do have a very US perspective because a lot of the laws we talk about, including Section 230, are US laws that have global impact. And so what we tried to do there was talk about the global impact without talking about how these laws look in every country. And my hope is that other countries will have their own volumes of feminist cyber law, because each country, each region could truly fill a volume in and of itself. So rather than try to just cram that stuff in at the last minute, or cram it in the last 2 pages of a 50 or 60 page article, I do usually try to up at the top say, yes, this is limited, but that's because of my own limitations, not because the other issues are not important. And so to bring you to the final issue about how public domain reifies implicit biases, absolutely. And in the paper, I do a long section about how the public domain is kind of the original biased low friction data. The word queer has transformed so far beyond how the Marquis of Kingsbury used it to refer as a slur to Oscar Wilde for having an affair with his son, to the way that now a teenager might ask Siri, hey Siri, am I queer? Well, if queer is given the meaning that it was used in these public domain works, Siri's not going to have a good answer to that question, and we are leaving our most marginalized people without answers. And so I think that that's why we need to see the public domain is an opportunity for training data, but we want to be mindful that we're not just highlighting and implicating and amplifying and reifying the biases that are encoded. Because if you want to make woke AI, as a lot of people would disparagingly call it, but I would just say accurate AI, if you want to make accurate AI, you have to remember that accurate in the 1920s looked very different than what accurate means today. And the alternative is that it looks biased.
So that sounds like, Amanda, your argument for why public domain works aren't a sufficient answer to the bias problem. You also mentioned that you had an argument for why Creative Commons doesn't fill the gap too. Do you want to speak a little about that?
The Creative Commons kind of falls prey to the same issue. The example that I use is Wikipedia. The former executive director of the Wikimedia Foundation, Catherine Mayer, said that something like 80% of AI gets its facts from Wikipedia. Just facts. And those may seem non-controversial and neutral. But the example I give is that the article about the Arsenal Football Club is many, many footnotes long. It is a lengthy article that goes into a significant amount of detail. And when you compare that to the article about Stanley Titus, the first woman admitted to the New York bar, she doesn't even have an article. So when we talk about facts not being biased, they are biased. And this is possibly because, and I would say probably because, there is a bias in Wikipedia editorship. There are similar biases in other types of, not necessarily Creative Commons to the same extent, but other types of open knowledge projects. They often attract middle-class men who are educated. They tend to be from the global north, who contribute to actually doing this work. And their work is really important, but sometimes those people don't observe the biases that are right in front of them. And I'll give you an example from my own practice. When I started falling in love with the work of Barbara Ringer, I decided to update her Wikipedia article, which for some reason mentioned in the first paragraph about this woman who drafted the 1976 Copyright Act, was the first woman register of copyrights, got the job for a successful sex and race discrimination lawsuit, even because she was a white woman, because she was so active in arguing for equality at the Copyright Office. And in the first paragraph of the article, it mentioned that she was unmarried and childless. That is a fact, but the inclusion of that fact betrays the biases of the editor who edited that article to begin with. And when I came in to edit the article, I stripped all that shit out because I was like, this is gendered and irrelevant. So the facts seem like they could be really neutral to use a Creative Commons licensed work like the Wikipedia corpus, but there are biases embedded in it because it has limited participation by a specific subset of people. I'm one of like 10% of women who edit Wikipedia, and I'm sure that a lot of those people do not adequately represent the full geography of the world who relies on Wikipedia for reliable information. Rant over.
I was just thinking, I mean, I'm not so, I haven't read so much into the Digital Millennium Copyright Act, but I was just thinking, is there any provision within it that leans towards fair use of AI to the extent that AI feeds from the internet?
That's a good question. So the DMCA has two big bulk provisions. The first is notice and takedown, which allows you to see that your copyrighted work has been infringed upon on the internet, and you can send a notice to the people that posted or hosted the infringement and request that it be removed. That's section 512. That's like one piece of the DMCA. That piece of the DMCA doesn't really get us very far unless we're talking about researchers posting their training data publicly and getting DMCA takedown requests from corporations like Getty, who own the copyright in some of the images in the data set. Wow, that was a mouthful. It's remote. The DMCA is not likely to play a huge role there. There's another part of the DMCA called section 1201, and that basically says you can't circumvent a digital rights management technology that is wrapped around a copyrighted work. That's an oversimplification. Now, there are exceptions for when you can do that. Those exceptions are granted by the Librarian of Congress every 3 years. There's a big hole to do. Lots of people write in and say, this needs an exemption, this needs an exemption, this needs an exemption. But even if you are going to go make fair use of the work, you don't always have full legal certainty that your ability to circumvent the DRM empowers you to do that, which is really tricky. So I think that the takeaway is that a lot of AI creators are either going to secretly hack DRM, or what's probably more likely is they're going to turn to bias low friction data, right? It's easier than having your team get around DRM after DRM in order to use the underlying corpus. Just use the public domain, just use Wikipedia, just use the Enron emails, and that's how we end up in these kinds of situations. So while neither part of the DMCA or these operative provisions really speak clearly to AI training data, they both influence what can happen with the training data if it were posted publicly and in the obtainment of it.
For the purpose of scientific research, there is a dependence of from these big corporations that actually have create the ability to process and to create these corpuses to undertake text and data mining. The thing is, in order to avoid that dependence, how to assess the market power of these corporations, and do you think that competition law can be a good tool or the good way to determine that there is a market position that is making difficult for others to undertake scientific research?
I think you're asking a really important question. Is there a competition issue? Absolutely. Is it something that competition law, I'm thinking of antitrust specifically, although unfair and deceptive trade practices may play a role in some circumstances. I don't think antitrust can fix it. And the reason is, while there is limited competition, none of these one companies hold a monopoly over AI technology. But my understanding is that in order for there to be a real action to bust up some of these giant AI companies and turn them into more constituent parts, we would need to have a monopoly somewhere. And unfortunately, while it doesn't feel like there's a lot of competition when it's the same 7 companies, that's 6 times as much or 7 times as much competition as the law is willing to tolerate in a lot of circumstances. So there's not necessarily going to be an antitrust action busting up these companies. Whether or not we might be able to do something with unfair and deceptive trade practices, that's very possible. That's a really sideways way to go about it, but some of these technology companies make public statements, especially smaller companies, not so much the big ones that actually do perform at very high levels. But some of these companies say that their face recognition is so accurate that it eliminates civil liberties issues. That seems unlikely. In fact, that might be a deceptive statement or an unfair trade practice under UDAP law. Every state and many territories have UDAP laws. It's not technically competition, but it is another sideways way at getting across some of these issues around misrepresentations of accuracy and quote unquote fairness made by some of these technology companies. The FTC would be in a good position to litigate some of that stuff, especially now that the FTC is looking so flippin' dope these days. They may really decide that they want to go after some of these companies that overstate what their AI can do. State AGs may find that particularly sexy now because tech is, to some people, very sexy. However, neither of those things, to my knowledge, have happened yet. Specifically about representations around accuracy, although there was an FTC action that required the divestment of AI training data for other reasons, if I remember correctly.
And yeah, I mean, a quick primer on that. So, you know, US antitrust law differs from competition law in most countries in that we have no abuse of dominance standard. So that's the kind of, that gets over into the consumer protection of the FTC might enforce things that similarly exist in competition laws around the country. But your basic EU standard, which is more common in most of the countries you're from, has both a monopolization standard, which is the only thing we enforce in the US, is the action has to increase your monopoly, either has to give you a monopoly or increase your monopoly power. Where in the EU, there's a separate abuse of dominance standard that says if you have dominance, then abusing it in various ways, including potentially refusing to license access to whatever you have, and including potentially refusing to license and access to an essential facility, for instance, which various kinds of information resources have been held essential facilities in the EU. So there might be certain ways to get there. I don't hear enough to actually tell you what the cause would look like, but so if you started making a claim that, for instance, Facebook is the only one with all that data, you render it an essential facility in order, in order to do similar kinds of things to compete with the owner in the market, you need to have access to that data. Whether you could get to like in order to validate or check, I'm not sure, it's not intuitive that it would get there, but I mean, it might be worth reading. I would say, if you want to research that, totally go for it, because there's a rich literature on different ways those, especially EU competition norms, can regulate intellectual property or information resources. And teasing it out in this context is not something I've seen anyone do.
Amanda, I loved your presentation. It was really useful. And I want to hear your opinion about this issue. I actually agree with you that Creative Commons, like in the example you gave about Wikipedia, that is actually biased because many of the articles is written by men. However, don't you believe that also copyrighted works have the same issue? And I'm saying this because I used to work in a university where the faculty members at law school, we were only 2 women out of all the professors. And most of the time, whenever I go to a conference, most of the time I'm the only woman, and the other like panelists are men, and they believe they have the final word. So I believe that most of copyrighted works are produced by men as well. So don't you think that this copyrighted material cannot actually fix that bias problem?
So, couple things. We have a sampling problem and we have a production problem. The production problem is quantifiable. It's, while not all copyright owners, like, I'm trying to think of a way to frame this that's concise, but all genders create copyrighted works. The question is whether or not there's a way to measure those. We can't measure every grocery list you write and every paper I write and every note that Sean writes, right? We can't measure that. What we can measure is copyright registrations. And here in the United States, the Copyright Office has done an audit. It is not parity. Men and women are not registering works at the same rate. However, more than almost 40% of copyright registrants are women, to the extent that that information is knowable from the face of the registration. So while it's not parity, it's also not as bad as Wikipedia, right? We're not talking about 10% of women, we're talking about 40% of women, which is a big difference. However, you don't have to use that corpus. If you wanted to only train the AI on works by women, if you wanted to go a step further and only train it on works by incredible Black feminists like Audre Lorde and Bell Hooks and many others, you absolutely could. It's all about thinking critically about the training data before just using what's easy, right? Biased, low friction data doesn't get us a way to fix the implicit biases in these systems, which can be deeply harmful, as we've been discussing for the last hour. What we need is some critical thinking around curating these examples. And that means curating examples of saying it can be harmful to potentially use particular works by oppressed people to train AI training, to train AI systems, such as in the context of face surveillance. If you're doing text and data mining and you're trying to notice linguistic biases and tics around how people write about particular other people, having a range of marginalized experiences representing in that corpus is going to be critical to produce something that is actually adequate and accurate for like productive public benefit research. Does that answer your question?
Yes, it does. Thank you so
drop a
much.
There's also a study from a couple of years ago, so it's probably a little outdated. I'm about to drop 2 studies in the chat. One is about copyright registrations by race and gender, because obviously race is a huge part of this issue as well. And then I'm going to drop the link that I was just quoting from, I believe from the Copyright Office. Yeah, it is from the Copyright Office. About how many women are in the copyright system. And again, we can't measure how many people create copyrighted works. People of all races, genders, abilities, sexualities are not necessarily creating copyrighted works at the same rate, but they are being created. The best proxy we have here is measurement through registration, even though, like, for example, if you are an inmate in a federal prison, you may be creating copyrighted works all the time that you would love to secure copyright registration to, but it costs money and you may not have the money to do that. So the voices of incarcerated people are going to be limited in a lot of contexts from these data sets. And for some applications of AI, that's totally fine and that's not a problem. But for other applications of AI, having those voices included in the data set may be really urgent. And we may need to think critically about whether there's some way for the Copyright Office to make fees discretionary for certain people, such as children or people who are incarcerated, who may not have the money to otherwise register a copyrighted work.
I have a question about it is if you know about some case or any case in which copyright owners, American copyright owners, rely on laws from outside US. I am talking about transborder issues because as we all know, there are a lot of transborder issues with copyright. And if copyright owners is in any case rely on laws from outside the US where there is no fair use, in the cases of countries where there is no fair use, to sue researchers who do AI processing with their works, because we know that the results of the AI process sometimes is available worldwide. So I don't know if this is possible, and what is the extent in which they can sue the researchers, because the processing may be done in the United States, but the results of this research may be available in other countries.
We actually have an example of American copyright owners suing researchers here in the United States for making copies of other scholarly works to use for research. The case is about Texaco, not the most sympathetic. It wasn't a really sympathetic defendant in the 90s when this case was decided. It's really not a sympathetic defendant now. I don't think anyone feels good about Texaco not paying their dues to researchers, particularly because they were probably doing something nefarious with the research to destroy the climate to begin with. However, that being said, the copyright owners did successfully sue Texaco, and Texaco argued that their use was fair use, and the court said it was absolutely not fair use. I don't know, however, this case is from, I believe, 1995. I don't know if this case would come out the same way today, especially with some of the leaps and bounds. This was only 1 year after Campbell versus Acuff Rose was decided, which kind of embedded transformativeness into that first factor of the fair use test. That has become way more popular with many courts now, including in the Second Circuit, which is one of the most transformativeness embracing jurisdictions, arguably, that exists now. So this case may turn out differently today, but in the 90s, it didn't. Texaco was found liable for copyright infringement for making for photocopying articles from journal subscriptions for their work. So not exactly what you asked for, but the closest my brain can currently get before noon.
So Amanda, your description of a bunch of the case law, especially the Sega and the iParadigms case, as really turning on the uses not using the creative aspect of the works, reminded me of Japan's law, which I referenced. Have you seen that before, Amanda?
Japan's I have not seen Japan's law, but I would love to.
Oh, you're gonna love it. Okay, here it is. It's like reading a Matt Sag article.
Oh,
in the copyright
beautiful. You
law.
love to hear it.
So this is Article 34, 30-4. It's pretty new. I think it was, yeah, it looks like 2018 was when it was enacted. The purpose was to authorize text and data mining, but they adopted what we call a general approach, in the sense of, instead of saying like Germany's law that you can make reproductions to create a corpus for text and data mining, very specific, that one specific aspect. It actually defines a general exception, a general purpose of exception, and then it gives some such as, and includes, like fair use, includes the text and data mining in the such as. And this is the language translated to English. So I don't know, exactly what it is in Japan, but I love the English translation, which is, it is permissible to exploit, so that's like use, right? Exploit a work, any work, in any way. I love that qualification. Exploit was already perfectly open and broad. Can exploit a work, any work, in any way, to the extent considered necessary, so not necessary, but the extent considered necessary, in any of the following cases or other cases where such exploitation is not for, and this is my favorite part, enjoying or causing another to enjoy the ideas or emotions expressed in such work. And so it's really that not using the creative aspect, right? And then if you can see it down in the ... there's examples. Yeah, go ahead.
What I think is fascinating is I'm not so familiar with Japan's copyright system, but here in the US, you wouldn't need to qualify ideas because anyone can use an idea. But emotions is fascinating because that is so such a, I mean, honestly, frankly, elegant way to capture such a breadth of other potential uses. But what I'm stuck on is enjoy, because I know that they don't mean enjoy as in delight in. I know that they mean just use, but choosing to say enjoy even in the translation gives the impression that you're capturing the critique and commentary piece from Section 107 in US law, because if you don't enjoy the work, you are probably critiquing or commenting on it in some way. And again, I know that's not how the word is probably being used, but I love that there's like this nuance to it that kind of captures a little bit of that echo, if that makes sense.
Yeah. But so it's an example, Miguel, of a version of a very open and flexible exception that specifically mentions. So if you see, 1, 2, and 3, the 1 is exploitation for using the work in experiments, and then 2, exploitation for using the work in a data analysis, and then 3 in the course of like computer processing. So but those are such as, those are just examples. They're not exclusive. So it maintains itself in what we called in the first lecture an open general exception, but has very different framing. It doesn't ever use fair use. In fact, doesn't use the words fair or use. It uses exploit, and then, not for the enjoyment of the emotions in the work. As Amanda said, her paper is looking at a problem that can be perceived as global, but it's very much a local paper. It's very much a US law-centered paper. So one of the things that people can do is think about using that same analysis, but applying it globally instead of locally, or applying it within other countries. What is applying this kind of analysis look like in a place that doesn't even have fair use, or that has closed research exceptions? How does that affect global access to knowledge for good and bad purposes? And feel free to go both ways. Thank you for coming with us, Amanda. Please stay with us. We hope you'll be a continual part of this community. Your work has affected a lot of us, as I've mentioned to you before, and we're really happy to have you.
It was my absolute honor. You all asked banger questions. Thank you for challenging me to think so hard and so deeply, and this is going to stick with me for a while. So thank you so much, and I hope you take a look at some of those special bonus resources, because I think a lot of them are real fun.